2941.14.17. Further states that you understand that the maximum penalty for count 3 is a prison term of 8 years as set by the judge. That's the maximum that could be imposed by the judge. The minimum is 2 years in between 2 to 8, as chosen by the judge. Now, that's the maximum term set by the judge. Under what's called the Reagan Toast Law, which is on page 2, is described on page 2 of your agreement, persons that are convicted of second-degree felonies have to serve, in this case, it's mandatory. So whatever term I impose, you have to serve that. Whether it's 2 years or 8 years, you have to serve it. There's no early release or reduction other than jail time credit, and that will be served. Under the law, the Department of Rehabilitation and Corrections does have the authority, if they determine that it's necessary, to extend your time by up to 50% of whatever term is imposed by the judge. 50% being 1/2. And so if you were to receive the maximum sentence of 8 years, then that could end up being a 12-year sentence if the Department of Corrections, Rehabilitation Corrections felt that that's what was required in your case. If it were the minimum of 2 years, then it would be a potential maximum of 3 years. But whatever the number, whether it's 2 or 8, you have to serve every day of that. Beyond that is up to the Department of Corrections. You understand that?
Yes, Your Honor.
Now, there's also a possible fine of up to $15,000 for count 3. There's a mandatory fine of $7,500. And there's a license suspension that's possible, it's not mandatory, of 6 months to 5 years. Do you understand that?
Yes.
And again, you understand that in this case, there's no possibility of control or conditional release. Whatever sentence is imposed has to be served as far as what the judge has imposed.
Yes.
Now, under the law, once you complete the prison term that's imposed by the court, if you're convicted, the adult parole authority is required as part of the sentence to place you under post-release control supervision, which means you'll be supervised by a parole officer on the term set by the adult parole authority, because the judge has nothing to do with that. And for this offense, it would be a mandatory minimum of at least 18 months of post-release control supervision. And it could be at the discretion of the parole authority up to 3 years. But it would have to be at least 18 months. Could be 3 years. Again, they make that decision. If, during that period of time that you're under supervision, they determine that you have failed to comply with those conditions that they have set down, then they could return you to prison even though you served the entire prison term ordered by the court and any additional time that was required by DRC, for a period of up to 9 months for one violation. But there is a cap or limit of half of whatever prison term you serve for all violations. But if you commit a new felony while under post-release control supervision, then in addition to whatever sentence that the judge in that new felony case would impose upon you for committing that offense while under post-release control, that judge could also sentence you for committing that offense under post-release control, in this case, to an additional period of 1 year, or whatever time's left on the period of post-release control, whatever it was, whichever is more. And if that occurs, that would have to be served consecutively to the sentence in a new case, meaning after. You understand that?
Yes.
All right. Now, the charge in count 3 alleges that on or about October 25, 2020, in Highland County, Ohio, you, Caitlin R. Owens, did knowingly sell or offer to sell methamphetamine in an amount equal to or exceeding 5 times bulk amount or less than 50 times bulk amount, in violation of Section 2925.03A1 of the Ohio Revised Code. So that's the charge of the aggravated possession of methamphetamine, the third-degree felony, second-degree felony, aggravated trafficking of methamphetamine, and with the sentence, possible sentence of, let me back up, a mandatory sentence of between 2 and 8 years is set by the judge, the maximum of up to 50% of that sentence, in addition to being required to be served by a DRC, a fine of up to $15,000, a mandatory fine of $7,500, and a possible license suspension of 6 months to 5 years. You understand that?
Yes.
Now, count 5 alleges that on or about October 25, 2020, in Highland County, Ohio, that you and Caitlin R. Owens had in your possession a 2012 Chevrolet Sonic vehicle, that number set forth in the count, subject to forfeiture due to since brutality, commission, or facilitation of offense, and fine under 2941.14.17. So that would result in forfeiture of that vehicle to the state. If prison or monetary sanction. You understand that?
Yes.
Mr. Clemens, do you understand what it is you've been charged with, what the state said you did in each of those counts, what, when, where, and how they alleged you did?
Yes.
And you understand the possible penalties for each,
Yes.
for that?
Yes,
And
Your
again, you understand the prison term is mandatory, that the court has no discretion.
Yes, Your Honor.
Now, have you discussed the nature of the charge, the evidence in the case, the possible legal issues in the case, possible defenses you might try to raise as to each of these two counts, and possible outcomes of a trial with your attorney?
Yes, Your Honor.
Are you satisfied with her advice and confidence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Have any threats been made to get you to plead guilty here today?
No, Your Honor.
Now, on page 2 of the plea agreement, there are 4 lines that are printed in bold and underlined, which are the substantive terms of this agreement. So I'll read those for you into the record. Defendant shall enter a plea of guilty to count 3 and count 5. State will dismiss remaining counts. State defense jointly recommend 4 years mandatory incarceration. Defendant agrees to repay task force $890. Joint several with co-defendant. Defendant fully cooperate against co-defendant. Defendant agrees to forfeiture as outlined in count 5. Is that your understanding of the agreement?
Yes, Your Honor.
Does anyone promise you anything other than that to get you to plead guilty here today?
No, Your Honor.
Under the law, Mr. Clemens, a matter of sentence is up to the judge, not to the parties. And so even though there's a joint recommendation from both you and the state that the sentence should be 4 years mandatory, which is a mid-range, once that's not binding on the court. So once I've heard all the information, if you plead guilty to this charge or are convicted, then I could decide to impose any sentence between 2 and 8 years that I think is appropriate. And plus, there is a fine involved, a required fine of $7,500, and the fine could be up to $15,000. There could also be a license suspension of 6 months to 5 years. You understand that?
Yes, Your Honor.
Then, as to count 5, you understand that would be forfeiture of the vehicle.
Yes.
Okay. Now, do you hold any license or certification from any state agency that regulates any profession?
No.
Now, you have certain constitutional rights you must understand before I can accept this proposed guilty plea to these 2 counts. First of all, you have a right to have counsel. You did appoint Ms. Panzee to represent you. Now, in the event that you were not able to continue to pay her to represent you, then under the law, the court would appoint an attorney for you to continue to defend you, including a trial, if that's what you want. So the reason I say that is I just make sure you're not entering into this plea agreement because of a concern about not being able to pay for counsel.
No.
Right. Now, you have the right to have a jury trial on these 2 charges, in which 12 people would be selected from a group of citizens that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented, they be instructed on the law, and then that jury would have to decide by a unanimous verdict, meaning all 12 would have to agree on a verdict as to each of the 2 counts. Now, and they would then decide whether or not the state proved your guilt on either or both counts. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, which means give up your right to have a jury trial. And then in that case, you would have what's called a court or bench trial, which means that the judge would be the one to hear the evidence instead of the jury, apply the law, and decide whether or not the state proved your guilt, but proved beyond reasonable doubt. You understand that?
Yes.
Right now, under the Constitution, you have a right to confront witnesses against you and to cross-examine through your attorney. What that means is that witnesses against you have to come into court and testify in front of you, your attorney, and anyone else that may be present. After the prosecutor is done asking those witnesses questions, your attorney can ask questions. That's what cross-examination is, and the purpose of that is to try to bring out evidence that helps your side of the case. You understand that?
Yes.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses coming to court to testify for you, just like the state. So if you have witnesses you're uncertain are going to come in voluntarily, at your request, the court issues a court order, that's a subpoena, and that forces those witnesses to come to court and be able to testify for one of them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court to testify against you. Do you understand that?
Yes.
And under the Constitution, Mr. Clemens, you have the privilege against self-incrimination, which means you should not be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can, the judge can, you make that decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one can comment about it, except in one situation, that is, if there's a jury trial and you did not testify. The the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes.
Right now, under the Constitution, you are presumed innocent of these charges until proven guilty by the state of Ohio of every essential element of each offense by proof beyond reasonable doubt. What that means is that the burden of proof is on you to prove you're not guilty of these charges. Burden is on the state to prove that you are. In fact, under the law, you don't have to present any evidence in your own defense at trial. You may, but you're not required to. But whether you do or not, the burden remains upon the state to prove each element of or each offense by proof beyond reasonable doubt, which is the highest burden of proof is known under the law. You understand that?
Yes.
Right now, Mr. Clemens originally entered a plea of not guilty. Not guilty plea, denied the allegations in this indictment, denied you committed any crime, and exercised all the rights that I've just described. Now, if you change your plea from not guilty to guilty, that is a complete opposite of a not guilty plea. A guilty plea admits the allegations in the indictment, admits that they're a crime, admits that you're the one who committed that crime. And that plea wagers up all the rights that I have described for you this afternoon, except your right to have an attorney, which you always have no matter what you plead. But with that exception, your plea of guilty wagers up your right to a jury or a court trial. It wagers up your right to confront witnesses and cross-examine them through your attorney. It wagers up your right to use the power of the court to compel or force witnesses to come before to testify for you the same as you say. It wagers up your privilege against self-determination because if you say you're guilty, that's what you find you guilty. It also wagers up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it wagers up any right to file an appeal that you think you may have had up to this point in the case. Now, if I should sentence you to the maximum sentence, or under other certain circumstances, you can file an appeal that would have to be filed in 30 days, and your sentencing entry would be filed. Do you understand all of that?
Yes.
And are you a U.S. citizen?
Yes.
And did you enter into this agreement to plead guilty voluntarily?
Yes.
Now, do you have any questions about the charges and possible penalties?
No, Your Honor.
You understand them?
Yes.
Any questions about the plea agreement?
No.
You understand it?
Yes.
Again, you understand the recommendation on sentencing not binding on the court.
Yes, Your Honor.
Do you have any questions about the constitutional rights of this claim?
No.
You understand those?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, and what the consequences of that could be if you plead guilty?
No, Your Honor.
You understand?
Yes, sir.
Is there anything you'd like to speak to your attorney about before we go any further?
No.
Do you have any questions from the court of anything I explained to you?
No.
One other thing I needed to make, made a mental note to ask this earlier that I overlooked it. The agreement doesn't provide for you to cooperate against the co-defendant, and I just took a glance at the other the form and said the same thing. And you're being represented by attorneys in the same firm. You have no problems with going ahead and going forward. You don't feel there's any conflict of interest that has any effect on your plea here today.
No.
So you're okay with that? You don't feel that's a problem?
No.
Would you wish to address that at all, Ms. Panzica?
Judge, and I think we addressed it at the arraignment.
We did.
Yes, but we
I
did.
just want to redo it for the record.
Yeah, and we did speak with Mr. Clemens. I know Mr. Wiley spoke with Ms. Owens. There has been no potential conflicts that have arisen, but we've gone over all his rights, everything else, to make sure that that wasn't going to be an issue.
Okay. And again, you're comfortable with that?
Yes.
Okay. All right. Then is it your decision, Mr. Clemens, to withdraw your not guilty plea, plead guilty to counts 3 and 5, according to the terms of the plea agreement that we've just done?
Guilty.
Yeah, I mean, is it personal? Is that your intention?
Yes.
Okay. All right. Now, as to count 3, which alleges that on or about October 25, 2020, in Highland County, Ohio, that you and Caitlin R. Owens did knowingly sell or offer to sell methamphetamine in an amount equal to or exceeding 5 times bulk amount but less than 50 times bulk amount, violation of section 2925.03A1 of the Ohio Revised Code, charged with aggravated trafficking of methamphetamine, a second-degree felony, which carries a mandatory sentence of at least 2 years, up to 8 years, as imposed by the judge. The possibility that any sentence imposed by the judge would be subject to being extended by up to 1/2 of that sentence by the Department of Corrections, Rehabilitation Corrections. A fine of up to $15,000, a mandatory fine of $7,500, a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
Now, as to count 5, which alleges that on or about October 25, 2020, in Huntington County, Ohio, that you and Caitlin R. Owens had in your possession a 2012 Chevrolet Sonic, VIN number set forth in the indictment. Count 5, subject to forfeiture due as instrumentality in commission or facilitation of the offense as defined in section 2941.14.17, a charge of the forfeiture specifications subjecting that property being forfeited to the state. How do you feel?
Guilty.
All right. The court finds that on this day of the court, defendant was advised of all his constitutional rights, made a knowing and intelligent voluntary waiver of the same, pursuant to Rule 11. Plea is accepted and ordered filed. The defendant is found guilty of counts 3 and 5 as set forth in the indictment. Counts 1, 2, and 4 are dismissed. I believe it's a request for a pre-sentence investigation, and it was just a mandatory sentence. The nature of the charge, the court, I believe, will go ahead and proceed sentencing for you. Anything from the state regarding the sentencing?
Thank you, Your Honor. State would ask that the court follow joint recommendation. The forfeiture of the vehicle in count 5 would be to the Highland County Task Force. The clerk will need to issue a title for that vehicle to the Highland County Commissioners. And the total restitution in this case, as indicated in the plea agreement, is $890. The task force joint several will be good for that. Thank you.
All right, Ms. Kinsey.
Judge, just briefly, Mr. Clemens is 28 years old. He and Ms. Owens do have custody of their 1-year-old son. Mr. Clemens has been fully cooperative with the state of Ohio and the investigator, which is why we are asking that you do not review 3 4-year sentence.
By the way, I apologize. I think I said your name is Christine, and that was Chelsea.
That's okay.
All right, Mr. Clemens, you have anything you'd like to say?
No, Your Honor.
All right, before the record, the court will note that according to the discovery compliance, the defendant was convicted in 2014 on 4 counts of trafficking drugs and received a 3-year prison term. Also has a previous conviction in Adams County for a 1-year prison term from 2018. So this will be your third number.
Yes, sir.
How old are you?
28.
28 years old. So you've had 4 years in prison, and you're going to do the next 4 at least in prison. So, yeah, assuming you get out without an additional time, it's going to be 8 years out of 32. That's 1/4 of your life. So, you know, and it looks like the primary issue is your drug dealing. The best thing I can tell you is that you know, you need to get a different line of work. Because the risk rewards, I don't know. I mean, I don't know how much it would take to get me to spend a year in prison, but I'm sure there's not one on the planet. And you know, you need to start thinking about that. Because whatever reward you're getting from this activity, I don't think it's worth missing 4 years of your child's life. That's what's going to happen. So it is the judgment order of the court that you be and are hereby sentenced to the Correctional Reception Center at Warren, Ohio for a period of 4 years mandatory time, which is required by statute. According to the sheriff's record, you had 2 days of jail time credit, arrested on the 25th of August, released on the 26th. Is that correct?
Yes, sir.
Right. So you get 2 days of jail time credit. Now, as I indicated, this is a mandatory term that has to be served, minimum term as imposed by the court. Under the Reagan-Tokes law, upon completion of that 4 years, the Department of Rehabilitation Corrections could decide that you should have that period extended by up to 50%. So that means that there could be a maximum of 6 years. They'll make that decision. The court has no involvement in it. And upon completion of whatever prison term is imposed or is served, then it will be mandatory that you be under post-release control supervision of the adult parole board for a period of at least 18 months as a minimum, up to a maximum of 3 years as they determine under the terms and conditions that they set. If they determine, the adult parole board, that you have failed to comply with those conditions, that they can return you to prison, make you serve an additional period of up to 9 months for any one violation, up to a maximum of half of your prison term for all violations. However, if you commit a new felony while under post-release control supervision, then in addition, whatever sentence the judge in that new case would impose upon you, the judge can also sentence you in this case to an additional period of 1 year or whatever time is left on the post-release control period, whichever is greater. If that occurs, that has to be served consecutively the sentence of the new case. Court also imposes a mandatory fine of $7,500 as required by the statute, and it's also ordered that you pay as part of the sentence $890 in restitution, joint and several, to the Highland County Task Force. That would be paid through the Victim Witness Program's escrow account for victim restitution, and you'll pay any service fee that's required of that, and currently it's $5. You're also ordered to pay the court costs, and that is joint and several. You also require to pay the court costs. If you fail to do that or make payment arrangements, then the court will collect that for various means, including letting bank accounts, wages, earnings, their assets that you have. That doesn't collect that on condition of your prison term, not while you're in prison. Once you get out, what could order you to do through service with respect to each hour you work in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until payment. All right, is there anything further?
I may have missed it, Your Honor, but the forfeiture was up over.
No, the vehicle, count 5 thing, is described in count 5 is ordered to report Highland County Task Force tied to the Highland County Commission. All right, then you're remanded to custody, Mr. Clemens.
Thank you, Judge.
You need a break, sir, or are you ready to go?
Take a load. It's case number 21 CR 135. State of Ohio versus Caitlin R. Owens. Present for the state, this is Dr. Kane, present for the defendant's attorney, Pat Blau. And you are Caitlin R. Owens.
Yes, Your Honor.
Ms. Owens, the post-benefit case we just had in prior, Brian Clemens II. She was indicted along with Mr. Clemens in a 5-count indictment, 2 counts of aggravated traffic methamphetamine, 2 counts of aggravated possession of methamphetamine, and a corporate preservation back on August 3rd of last year. This matter was continued for previously scheduled hearing and been presented with a plea of guilty form as Owens, which indicates that you're going to withdraw your not guilty plea, plead guilty to count 1 and count 5 of the indictment. Now this form is 3 pages, and on page 3 there is about halfway down a sentence that reads, "I entered this plea voluntarily." And And immediately below that, there's a line with signature dependent print below that, and what appears to be the signature of Caitlin Owens. Is that your signature I'm looking at?
Yes, Your Honor.
And when did you sign this document, Ms. Owens?
Today.
And did you go over it with your attorney before you signed it?
I did.
When you signed it, do you understand that it was an agreement to plead guilty, which means it won't be a trial, the next step in your case will be a sentencing hearing?
I did.
And had you been discussing this agreement with your attorney before you came here today?
Yes, Your Honor.
When you came here today, did the contents of this agreement, were they the same as what you understood they would be when you came?
Yes, Your Honor.
Feel you've had enough time to fully consider this matter before making this decision?
Yes, Your Honor.
Have you been pressured or rushed in any way to making this decision?
No.
Right? And are you entering into the agreement to plead guilty voluntarily?
Yes, Your Honor.
Right now, the agreement states on page 1 that you're going to withdraw your guilty plead guilty to count 1, aggravated trafficking of methamphetamine under 2925.03A1 of the Ohio Revised Code, a third-degree felony. Count 5, forfeiture specification under 2941.14.17. Now, further states that you understand that the maximum penalty for count 1 is 36 months in prison. The minimum prison term is imposed is a 9-month period. Then there are different increments in between. It goes from 9 to 12, and then every 6 months up to 36 months. And a fine of $10,000, a mandatory fine of $5,000, and a possible license suspension between 6 months and 5 years. And the prison term is not required in this case, as it was in Mr. Clemens's. There's a presumption that there should be a prison term imposed in the law, which simply means that that's what the legislature opinion is. The sentences would normally be in this case, but it's not mandatory. Final decisions up to the judge. You understand that?
Yes, Your Honor.
And are you facing any felony charges in any other jurisdiction?
No, Your Honor.
And you're not currently on probation, parole, pre-control, post-release control of any jurisdiction?
No, Your Honor.
Now, under the law, you are convicted of this offense, and if you should be sent to prison, on completion of the term imposed by the court, it is possible that the adult parole authority would put you under what's called post-release control supervision for a period of up to 2 years. Now, they don't have to, it's discretionary, but it's up to the adult parole authority. The court has no involvement with that. If they decide to do that, then you'd be supervised under the conditions that the parole authority says, because the court's not involved with that, or that period of up to 2 years. And if during that time they determined that you had failed to comply with those conditions, then they could return you to prison even though you served the entire term by the court for an additional period of up to, in this case, 9 months would be the maximum, but there would be half of whatever prison term is imposed for all violations. But if you committed a new felony while under post-release control supervision, then in addition to whatever sentence the judge in the case could impose, finally that judge could also sentence you to an additional period of 1 year or whatever time is left on that period of post-release control, whichever is greater, and that term would have to be served consecutively to the sentence in the new case that occurred. Do you understand that?
I do.
Now, even though there's a presumption there should be a prison term imposed, it's not mandatory. And so, under the law, the court could impose what's called a non-prison or community control sanction. What that means, community control is basically what people know to be probation. And that means that instead of going to prison, you can put under the supervision of a probation officer on a term set by the court. That could be for up to 5 years. Now, if during that period of time, the probation department felt that you were not complying, they would have to file a written allegation of that with the court, provide a copy to you, and then you would be entitled to have a hearing at which you would be could be represented by counsel. If the outcome of that hearing was that you failed to comply, then at that time the court could revoke your community control and then sentence you to prison for a period between 9 and 36 months in increments provided by law, and fine you up to $10,000. Do you understand that?
I do.
Right now, count 1 alleges that on or about October 21, 2020, in Highland County, Ohio, Brian Clemens II and you did not only sell or sell methamphetamine, Schedule 2, controlled substance in amount equal to or exceeding bulk amount less than 5 times bulk amount in violation of Section 2925.03A1 of the Ohio Revised Code. And so that's the charge of aggravated possession of methamphetamine, third-degree felony, penalty of this discharge. Count 5 alleges that on or about October 25, 2020, County of Ohio, that Brian Clemens II and you had in possession of 2012 Chevy Chevrolet Sonic. VIN number set forth in count 5, subject to forfeiture due to assistant battalion commissioner facilitation of the offense, as defined under 2941.14.17. So that charge of convicted means that the property will be forfeited to the state. There's no prison term or financial sanction. You understand that?
Yes, Your Honor.
Now, do you understand what it is you would charge with by the state in each of these two counts, what they said you did, when, where, how they alleged you did it?
Yes, Your Honor.
Have you discussed the nature of the charges, the evidence in the case, the possible legal issues in the case, the possible defenses you might try to raise in trial, possible outcomes of the trial with your attorney?
Yes, Your Honor.
Are you satisfied with his advice and comment?
Yes, Your Honor.
And I'm going to pause here and go over what I did with Mr. Clemens, and that is that Mr. Blau and Ms. Menzigner are both the same law firm and represent both you and Mr. Owens, Mr. Clemens, Ms. Menzigner did. And you discussed with them that issue, and you don't feel there's any problem with any conflict by the two of you being represented by lawyers in the same firm.
Correct.
Okay, you feel comfortable with one.
Yes, I do.
And is there anything you'd like to add to that, Mr. Blau?
Judge, the only thing I was going to say is we understood the potential conflict from the very beginning of it. What I'd like to say is if you disagree with anything I'm about to say, please let me know. We've both talked with, I've met with and talked with Ms. Owens on numerous occasions. I'd say almost every time, if not every time, we've discussed that potential conflict and how we have to separate and what I have to watch her as an individual. Would you agree with that?
I do.
Okay, thank you. Now, are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Has anyone threatened you to get you to plead guilty here today?
No, Your Honor.
Now, on page 2, there are 4 lines down at the bottom that are printed in bold and underlined, and I'll read those at this time. It says, defendant shall enter plea guilty to count 1 and count 5. State will dismiss the remaining counts. State defense jointly recommend committee control. Defendant agrees to pay task force $890. Joint several with co-defendant. Defendant will cooperate in fully against co-defendant. Defendant agrees to forfeiture outline in count 5. That's your understanding of the agreement?
Yes.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, Your Honor.
Under the law, it's a matter of sentence. It's up to the judge, not to the parties. And so even though there's a recommendation from both the state and you that court sentence should be community control, I'm not required to follow that. So once I hear all the information presented to me, if I decide that's not the correct sentence, I could impose a sentence of between 9 and 36 months in the provided by law on count 1, in addition to the fine and the license suspension. You understand that?
I do.
Your Honor.
Yeah.
I'm sorry to interrupt. I spoke with the state quickly, and obviously it's your decision. We would be willing to waive a pre-sentence investigation if and argue sentencing right now. We are ready to go if you would allow such.
Well,
I think
for a case of this nature, I would require pre-sentencing.
no problems.
Now, do you hold any license or certification from any state agency that regulates any profession?
No, I do not.
Now, under the Constitution, you have certain rights you must understand before I can accept a plea of guilty. First, you do have the right to counsel, and you employ Mr. Blount to represent you. Now, in the event that you were unable to continue to pay him to represent you, the court would appoint an attorney for you at no cost to you to continue your representation, defending you, including in trial, if that's what you want. And so the reason I bring that up is just to make sure that you're not entering a plea of guilty because you're worried about having enough money to pay Mr. Blount. Is that a consideration whatsoever?
No.
Thank you. Now, under the Constitution, you have a right to have a jury trial on these 2 charges in which 12 people be selected from a group of citizens from this county that were summoned for jury duty on your trial date. After they were selected, the evidence would be presented, the jury would be instructed on the law by the judge, and that jury would decide by a unanimous verdict, meaning all 12 would have to agree on whether the state proved your guilt on either or both charges. So they had to be unanimous on each charge. If you didn't want to have a jury trial, but you didn't want to plead guilty, then you could waive in writing, which means to give up the right to have a jury trial. And in that case, you would have what's called a court and bench trial, meaning the judge would be the one to hear the evidence, apply the law, decide whether or not the state proved your guilt or proved beyond reasonable doubt. Do you understand that?
I understand.
Now, under the Constitution, Ms. Owens, you have a right to confront the witnesses against you and to cross-examine them through your attorney. So what that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present in an open court proceeding. Once the prosecutor's done asking questions of those witnesses, your attorney can ask questions on your behalf. That's called cross-examination. And the purpose of that is to try to help your side of the case. Do you understand that?
I do.
Under the Constitution, Ms. Owens, you have the right to use the power of the court to compel force witnesses to come to court to testify for you, just like the state. So, if you have witnesses you're not certain are going to come involuntarily to testify, you can ask the court to issue a subpoena, which is a court order that would force those people to come to court to be able to testify for you, if you wanted them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
I do.
Now, in the Constitution, Ms. Owens, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you make that decision. And if you decide not to testify, the fact that you did not testify could not be used against you in any way by anyone at any time. In fact, no one's even allowed to talk about it, with one exception, which is if there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
I do.
Under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of each of these offenses. I prove beyond reasonable doubt. So what that means is that the burden of proof isn't on you to try to show you're not guilty simply because you've indicted. In fact, under the law, you don't have to present any evidence at all in your own defense at trial. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of each of these offenses by proof beyond reasonable doubt, which is the highest burden of proof that's known under the law. You understand that?
I understand.
Right, now, originally you entered a plea of not guilty. The not guilty plea denied the allegations in the indictment, denied you committed any crime, and that plea exercised or invoked all the rights that I've described for you today. But if you change your plea from not guilty to guilty to counts 1 and 5, that is the opposite of a not guilty plea. The guilty plea admits the allegations in those counts, and the indictment admits that they're a crime, that you committed that crime. That plea would waive give up all the rights that I've described for you here today, except the right to have an attorney, because you always have the right to have an attorney no matter what you plead. But without exception, your plea of guilty would waive give up your right to a jury or court trial, waive give up your right to confront witnesses against you and cross-examine through your attorney, waive give up your right to use the power of the court to compel or force witnesses to come into court to testify for you, the same as the state. Waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what you find you guilty. Or waive or give up your presumption of innocence, because if you say you're guilty, the state's not required to prove you're guilty. It subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal you think you may have had at this point in the case. Now, if I should sentence you the maximum sentence, or under a certain level of circumstances you can file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
I understand.
And are you a U.S. citizen?
Yes, I am.
And you did enter into this written agreement to plead guilty voluntarily?
Yes, I did.
Do you have any questions about the two charges or the possible penalties?
No, I did not.
Can I interject, Judge? Is there anything different that the judge said than that? He's went over a lot in details. Is there anything different that I said than that the judge just said to you? Any questions?
No.
Everything's consistent? Sorry, sir.
No problem. All right. Again, you understand the charges and the possible penalties.
Yes, Your Honor.
You have any questions about the plea agreement?
No, Your Honor.
You understand it?
I do.
Again, you understand that the recommendation on sentencing is not binding on the judge.
Yes, Your Honor.
Any questions about the constitutional rights I've explained?
No, Your Honor.
You understand those?
Yes, I do.
Do you have any questions about the plea of guilty, what it means, and what the consequences of that would be if you enter into here today?
No, Your Honor.
You understand?
Yes, I do.
Is there anything you'd like to speak with your attorney about before we go any further?
No, Your Honor.
Do you have any questions about anything that I've explained to you here today?
No, Your Honor.
Is it your decision, Ms. Owens, to withdraw your not guilty plea, plead guilty to counts 1 and 5 according to the terms of this plea agreement that we've just gone over?
Yes, Your Honor.
Okay, then as to count 1, alleges that on or about October 21, 2020, in Huntington County, Ohio, Brian Clemens II, and you did knowingly sell or offer to sell methamphetamine, Schedule 2 controlled substance in an amount equal to or exceeding bulk amount of less than 5 times bulk amount in violation of section 2925.03A1, charged with aggravated trafficking of methamphetamine, a third-degree felony, carrying a possible prison term between 9 and 36 months in increments provided by law, a fine of up to $10,000, a mandatory fine of $5,000, a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
As to count 5, that alleges that on or about October 25, 2020, in Piney County, Ohio, that Brian Clemens II and you had in your possession a 2012 Chevrolet Sonic VIN number as set forth in count 5, subject to forfeiture due to its instrumentality in the commission or facilitation of the offense, as defined in section 2941.14.17. The charge being a forfeiture specification, which would result of forfeiture of that property to the state. How do you plead?
Guilty.
Court finds on this date of the court and provides all the constitutional rights. Made knowing intelligent voluntary waiver of the same pursuant to criminal 11. Please accept it and order filed. The counts 2, 4 are dismissed. Court refers the matter to the probation department for a pre-sentence investigation, which will include the assessment deemed appropriate for substance use and or mental health disorder. Bond will be continued. So you report to probation immediately after getting out of there. January 31st, are you available that morning, Mr.
Chelsea generally keeps it, I turn my phone off.
Oh, okay.
So she's,
I'm pulling it up here.
Okay.
I'd be lost without her. I shouldn't say that for sure.
Yeah, not in public. They actually hold it to you.
And on the record.
Yeah,
Right.
record.
You said January 31st?
Yeah, 9 a.m. or 10 a.m.
9 a.m. should work. Civil jury trials, Mr. Copeland.
That's
Yeah.
not, can we do 9, sir?
Sure. 9:30.
Or 9, I'm sorry, yes, 9:30.
Okay. All right. 9:30, January 31st. So as soon as you get that signed, your assignment notice for your work on date, then you go down to report for probation. Unless do you have an appointment set up sometime this week?
No, today after
Okay,
court.
all right.
Yeah.
Go down to that, and we'll see Mr. Fulton, and he's usually the one that does the pre-sentence. Anything further, counsel?
No, Your Honor. No, sir, we appreciate your time.
All right, thank you.
Please rise.
I have the entry, Your Honor.
Okay. Thank you.
I tried.
Yeah, that's what I go with, so.
thank you.
I got it right there.
Oh, thank you.
No
problem. I just picked up my files.
Um, 02145. Ben. Hi, Caitlin. Yesterday I had an issue where I walked in the courtroom here and the speakers were flashing yellow and red and all that stuff. So I called Taylor and we reset some stuff on the big tower thing and everything came back on and everything started working again, normal. Well, this morning I came in, same thing happened. So I went ahead and did everything that Taylor instructed me to do last time. So it seems that it went back to normal, but it hasn't happened again. But I can't, when we get on Zoom, it's still recording, but when we go on Zoom, I could not see the judge on his laptop, and I tried to make a call via video, and it would not work. Our video conferencing isn't working. And Taylor did say something that he wanted me to call him back to get some sort of bug fix. I remember that. Absolutely. 937-768-3543. That's my cell phone. Yep. Okay, thank you so much. Bye. Okay.